Good morning, everyone. A very warm welcome to you on this lovely sunny day. Thank you for joining us on the latest Curious in a Crisis webinar this morning. Just to quickly draw your attention to the slide that you can see on your screen at the moment. I could just ask you to please keep your microphones turned off just for the time being, just to minimize any kind of technical disruption. That would be really appreciated. But we'd love to see who we've got in on the webinar today, so please feel free to use the chat box function to introduce yourselves and say hello, just as we wait a couple of moments to make sure that we've got everyone in from the waiting room okay. But it would be lovely to hear from you, who you are, where you're from, and what you do. Right, it looks like everybody has come in okay from the waiting room, so I think we will get started for today's session. So as I say, a very warm welcome. Thank you very much for joining us on this lovely sunny day here at Curious Minds. And hopefully what you should be expecting on today's session is a webinar about a beginner's guide to intellectual property law, specifically for online content. My name is Hannah Lambert and I work as the Programmes Coordinator for Curious Minds. And I'm joined on this morning's session by my colleague Jude Byrd, who is our Director of Programmes. So Jude, if you'd just like to say a quick hello.
Absolutely, people welcome. We devised this with our colleagues Counterculture because through our bursary scheme and the conversations we were having, it became very clear to us that a lot of you were transferring what you do to online content, and that whilst this may be somewhere you go in the future, a lot of people are gifting their online content at the moment. So in the brave new world, when you might want to sell your stuff, what are the implications? So we're going to be guided through this by Keith and Grace. And if yesterday's content is anything to go by, today you've got a treat in store.
Lovely, thank you very much for that, Jude. So that's correct. As Jude has said, we'll be going through the main part of the session with our guest and expert speakers, Keith Arrowsmith and Grace Asprey, and we'll introduce you to them shortly. But as I say, today's session is focusing on that beginner's guide to intellectual property for online content. Now, I can see in the session we've got a lot of familiar faces. Thank you very much for coming back to our webinars. It's so great to have so many of you back with us, but we do have one or two new faces as well in today's session. So just briefly, for the benefit of those people who may be joining us for the first time, I'll just very quickly tell you a bit about who Curious Minds is and what we do as an organisation. So Curious Minds is a registered arts charity. We're based in the Northwest region and we serve the Northwest region. And we exist to ensure that children and young people from the region have access to really high quality arts and cultural education and activities and opportunities. Now, the main body of our work is not actually direct delivery with those children and young people. We're here to support you as the professionals who do that direct delivery. So we're here to provide training and events around high quality arts and cultural provision for those children and young people in the Northwest region. And as Jude says, we've kind of developed this Curious in a Crisis programme as a response to the ongoing pandemic situation. So we had some consultation with freelancers and professionals from arts and cultural organisations when all of this pandemic started happening to us in March, to find out what it was that you really needed to know about to help you navigate yourselves professionally over these coming weeks and months. So that's how the content of these sessions has been devised. So just to give you a quick run through of how the next hour is going to look, we're going to be here till 11 o'clock this morning. And as I say, Keith and Grace will take you through the main part of the session shortly. They'll begin with a bit of a presentation, a bit of speaking from the front, just to ensure that you kind of have all the main content and that really essential information to kind of get you started on this subject. But we'd also love to hear a bit from you during this session. So a bit of discussion from yourselves, perhaps some real life examples that you may wish to share. Keith will talk you through that and will indicate when you can unmute your microphones throughout the session. We'd also like you to make use of the chat function throughout the session as well, so please do feel free to pop down any questions that occur to you during the session, and I'll be monitoring that, and we'll collate those questions and put those to Keith at the end of the session. And if you do experience any technical issues this morning, please also jot them down in the chat box. As I say, I'll be monitoring that, and I'll be here on hand to support you if you experience any technical problems there as well. And finally, just to reiterate for you that we are recording this morning's session, and the purpose of that is because we will be sharing all of these series of webinars up on the Curious Minds website at the end of this season of webinars, so that you can access the content at a later stage. So if you do not want to appear in that final recording, please just make sure that you keep your video turned off for the duration of this session. Now then, I'd like to take this opportunity now then to introduce you to Keith. Keith, thank you very much for joining us again. It's lovely to have you back with us this morning. And just before Keith tells you a bit more about who he is and what he currently does, just to let you know that he is a fully qualified solicitor, currently a senior partner at Counterculture. So Keith, as I say, a very warm welcome. Thank you very much for joining us again on today's session. And if you could just tell us a little bit more about your role at Counterculture and kind of how your career has got to that point where you're up to today.
Sure. Well, good morning, everybody. And it's lovely to be appearing here for the latest edition of Body with a Bookcase. And I think what we'd like to do with you today is concentrate on intellectual property. Now, that sounds complicated, and it's something that really has been part of the discussions around business for a very long time, but now we're working in a digital age. It's become more and more important for lots and lots of organizations. Counterculture is a business that uses that kind of technology itself, and we spend our time helping people in the cultural sector make the best use of all of these tools in both their charity worlds and the commercial world. I'm joined with Grace, who's one of my trainees, and she'll be helping me with some of the examples that we're going to be talking through. So I'm conscious we've only got an hour and we've got lots to go through, but I will divide up intellectual property into 6 segments. And at the end of each segment, we'll just touch base, make sure you're happy with that, and look at any questions you may have raised before I move on to the next. And then when we get to the end, we'll do a big old clear up to make sure we've covered everything. But we've only got an hour. If we're getting to the point where I'm giving things that are very technical or specific, I hope you forgive me if I say we'll park that for now. And if need be, we can always find a little bit of time where I can touch base with you after the webinar. So everything we'll do is of a general assistance. It's not going to be detailed legal advice, but we can always talk about any specific issues you've got later on. So I'm going to start with the bad news. And the bad news is that there is nothing in UK rules and regulations that will help protect your ideas. It sounds a bit shocking because that is our stock in trade. You know, what we're creating on a day-to-day basis and what we're teaching and sharing may well be the things that are of value, but the rule is we can't protect it, and we can't protect ideas because it's just, you know, we're having ideas all the time. I've certainly had half a dozen which are fairly decent this morning, but that's not enough. So what this thing called intellectual property will do is help you protect what you do with the ideas. So it's that next step in the process. So the top tip from me today is have lots and lots of ideas, but then select the ones that are going to make the best impact for you and your organization and your businesses, and concentrate on protecting the way that you're going to be using your ideas in the future. So it's an idea, it's lovely, but it's what you do with the idea that's going to count for intellectual property purposes. On that basis, you know, we need to kind of find a way of working that helps us find these brand new ideas and find ways of making money out of them. And that's one of the things I'm going to help concentrate in our session. I've got kind of a PDF of the notes that I'm going to go through for you, and I'm going to make sure that they're available for you at the end. And as I said, we're going to do some screen sharing as well, so we can use some examples that we've dealt with. If we're using real life names, we've got permission to do that. If I'm going a little bit hazy, it's because that's confidential and I'm not going to share that. But if there are some things that you'd like us to look at for your organisations, your businesses, then just let us know in the chat bar and we can pick those up as we go along. So, 6 sorts of intellectual property which can help protect the things that you do with your ideas. I'm going to start off with the first one, which also links a little bit to the last session we did yesterday, and that's names and brands, because everyone has a name, every organisation has a brand, and they may well be the thing that has the value for you going forward. It's your name, your reputation, and actually making sure that's protected might be the best thing to do given limited time and resources. And a name can be the name of your business or your organisation. It can be your own name if you're a freelancer or a sole trader, or it could be a brand that you've used that's other than your existing names for a particular job or a particular project or a particular type of goods or service, or it could be a brand, an umbrella brand for everything that you do. Now, all of those are protected. So I guess the first thing we ought to say is that before you start using a new name, a new brand, it's going to be worth doing a little bit of checking to make sure that you're not going to step on anyone else's toes. The last thing you want is to spend lots and lots of money setting up a new organisation, a new brand, a new business, and then find out that actually someone else is already using something that's the same as it or very similar to it. And especially if that creates a confusion in the marketplace. Because if it creates confusion, then potentially someone else is missing out. And then at that point, you could get the sneaky lawyer's letter that says, stop it or else. So where do we check? I'll give you the list of everywhere on the PDF handout, but where we'd start would be looking at company names, at the company's house website. We'd be looking at branding that have been registered at the Intellectual Property Office. We'd look on search engines, we'd look in trade journals or magazines, we'd look at obviously the social media accounts and domain name registrations. So there are lots and lots of places to check. There are lots and lots of tools that are online to help you check, and one of those tools is called Knowem, and I'll get Grace to type that into the chat bar for me. So it's Knowem, as in know, Knowem, Knowem.com. And that's where you can put in your prospective brand, and it will search all of the social media accounts and domain names and all the rest of it in one search. So you don't have to do lots and lots of different searches all the way through. That said, each country has its own processes and procedures. So if you're looking at expanding outside of the UK, you might just need to keep an eye on what's happening locally as well. So that's a tool called Knowem. There's another tool called the National Business Register. And again, I'll ask Grace just to pop that in the chat bar for you. But please, please, please don't register with the National Business Register. It's a commercial database, and you'll see that they're offering to do all sorts of things for lots and lots of money, but none of it is official, none of it's legal. It used to be back in the 1980s, but since then it's a commercial database that makes its money from receiving registration fees. And for the life of me, I can't see any value to having that registration through. So my tip there would be to save your money and use it elsewhere. So that's the National Business Register, and just don't go there because that's, in my personal opinion, waste of money. So what do you do instead? Well, the good news is that all brands are protected for free. Just pause there for a moment, because lawyers talking about freebies doesn't happen every single day of the week, but trademarks can be protected for free. And you know that they've been protected because there's an international symbol that people use to let everyone else know that it's a mark that has value and reputation and you want to protect it. And you might have seen it before, but it's the little TM that it's normally up in the air next to a brand name or a logo or a graphic. And that's the international symbol to say it's a brand. And it's great because it's free. There's nothing you need to do. There's no registrations. There's no paperwork. But the only thing it does is protect the reputation that you've built up. So if you're new to the marketplace, you've got no reputation that's been built up, therefore no protection. And it's quite difficult to prove that you've been using that mark and be building up that reputation over the years. So there's advantages to the freebie system. It's free, but there's also disadvantage to the freebie system. And that's because it takes quite a lot of time and effort to prove your reputation that sits behind the mark. So it only goes so far. But there's a second trademark system, and that's a registered trademark. And as the name would suggest, you have to go through a process in order for it to be valid. And the registration process means that once it's been completed, you can use a different symbol, and that's a capital R in a circle. And that is the international symbol to tell absolutely everybody in the world that it is a registered trademark. And once it's registered, it will protect from anyone else using the same or similar brand for the same or very similar goods and services. So there's a process you go through. It's all through the Intellectual Property Office here in the UK, and there are similar intellectual property offices all around the world. So once you've decided where you're going to set up, you can then apply for that process. And for simple applications, when we're only talking about one sort of goods or services that you're selling, a couple of £100 will get you 10 years worth of protection, which can then be renewed at the end of each 10-year process. So, for the equivalent of about £20 a year, you're getting the best possible protection for your brand. Now, I'm sure that that's not the most familiar thing that you've talked about so far. So I'm going to ask Grace to share her screen, and she's going to just take us through the database and do a little search to show what brands are protected now and the kind of freebie searches you can do on the register. If there's anyone who's got a brand that they'd like us to quickly check, as by way of an example, quickly stick it in the chat and we'll pick that up. And if not, we'll show you another one. But it's a simple process that you can apply online, and it takes a little bit of time, and it takes around 3-4 months for all the checking to be done. But once all the checking's been done, you get that registration. So here's Grace. Oh, that's looking really big, Grace. There we go. Thank you.
So it's really easy to find the IPO's database. It's as simple as typing in IPO into Google and going to the government website. And we're dealing with trademarks, so we go to trademarks. And under quick links, you've got search for a trademark. So this is how we're going to search the whole of the IPO's database. There's different options for how you can search it. All trademarks have their own registered number. You can search by the owner of the trademark, or if you want a more general search, which is what we're going to do, you go to keyword, phrase, or image. You can search by word or image or both. We're going to search for word because I've had a brilliant idea for a new chocolate bar called Cat Kit. So we type in Cat Kit. You can search for similar or exact trademarks to the one that you're searching for. You might run into problems if you do find any that are similar or that are the same. So you have to be aware that that can be an issue for you. Sometimes you might bring up so many different trademarks that the Intellectual Property Office won't show you them. If there's more than 1,000 results, it'll just say, sorry, we can't help you. So what can help sometimes is if you specify the goods or services that you're searching for. So in this case, I know that of the 45 classes, the class that I want is 30 because it relates to food. You can also narrow it down by the date that the trademark was filed. We're just going to keep it as it is, and you can make it show more than 10 results, so we're going to go for 50. The next page shows you all the registered trademarks that are either the same as or similar to the information that you've put in. So unfortunately, in this case, my brilliant idea of cat kit comes up as similar to Kit Kat. If we just take the UK registration, which is here, and we click on it, it brings up all the information to do with that registration. So you can see that this is a word mark, meaning it's just this word that's being registered. You can have a look at the goods that have been registered under it. So as expected, it's class 30 for food, such as chocolate. You can see who owns it. So it's Nestle in Switzerland. And you can see when it was first published in the Trademark Journal. So that's when it was first registered.
Great. I'm just conscious we've got limited time, Grace, but someone has, I think we've got a new suggestion to do another little search in the chat bar.
Fantastic. Here we go.
Anna, can you just let us know what it is, and then we can just search straight for it.
Yes, no problem. So the one that has come from Lisa is Hand on Here, which is spelled H-E-A-R.
Okay.
Art, A-R-T.
So that's a phrase, and phrases can be protected by trademarks. It doesn't have to be a single word or 2 words. It can be as many words as you like, as long as it is distinctive. That's the test. If it's just descriptive, then anyone can use those to describe their goods and services, and we're not going to get very far forward. But Hand on Here Art, that feels to me as a very distinctive brand. So on that kind of basis, that's looking good. There always ought to be a bit of a drum roll when we click the search button to see what comes up next. We'll leave the classifications blank just to have a wide as possible search as we can, and we're going to keep the search going back all the way to 1876, because trademark number 1 that was registered in January 1876 is still going. So we need to keep going all the way back through the full database. Here we go. Grace clicks the button. It's a big database, so it does take a couple of moments for it to come back with a search result. And we hope, we have fingers crossed. Let's see what happens when that comes back. When we search for a phrase, it does take a while. Now, here we go. So no one has registered a mark that the computer thinks is the same or is similar to that phrase. So that paves the way, that opens up the possibility for you to register your mark to protect it. And as I say, it's not the most expensive step, but sometimes, you know, I know budgets are tight, and sometimes if you're providing a range of services across lots and lots of different classes, as they're called, then the costs go up. So one class, like we've just shown you, class 30, chocolate, would cost you around £200 for the application. But if we were selling chocolates and we were providing education services, that's 2 sorts of different goods and services. The first would cost you a couple of hundred. The second would cost you 50 if you register for both at the same time. And every time you add on another goods or service with that initial registration, it's another £50. So most people are able to register what they need for a few hundred. So that's really nice news. That's clear for registration if you'd like to go there. But we'd recommend there's other searches and inquiries to make sure that all of those are covered. So thanks for looking at that, Grace. If you wouldn't mind just ending your screen share now, we'll go back and think around the next sort of intellectual property. So just to be clear, that's IP number 1. registration of trademarks and the free unregistered system of protecting for the names of the things that you're selling. So it's not about the thing that you're selling, it's about the badge, the logo, the graphic, the words, the phrases that you use to make your marketing pitch that makes your goods and services distinctive. And as well as all of those, you could use some things that are slightly more interesting, things like jingles, sound files. If that's the thing that you use to make your goods and services distinctive, then we can register that. If it's a colour that you use that makes your services distinctive, things like orange for phones or red for the Royal Mail, those particular colours are registered and protected as ways of distinguishing those goods from anyone else. And if we're going way out there, you can register your own smell. We'll just pause for a moment there while you all think about what smell would make your goods and services distinctive. And just to double check to make sure if anyone's got any more questions about that kind of protection, let us know now. And if not, I'll move on to IP number 2. Anna's going to let me know if there's anything there that's pressing. We can always pick them up again at the end if we're not sure. But that's the trademarky stuff.
Yeah, no problem, Keith. I think
Lovely.
we're still good to go for now.
Right, in which case let's move on to IP number 2. And this one is the patent system. And patents, doesn't matter what you call it, they are about inventions. So we are looking at a way of protecting something, again, and it can be an item, an element, or it can be a way of doing business or a scheme like that. But you can only get protection for it if it is brand new on the day when you fill in the forms. So on that kind of basis, we can't protect anything that's been seen before, and we can't protect anything that is so simple that it's obvious. So it's got to be new, it's got to be an inventive step, it's got to be something that's taking things forward, and you've got to be able to use it in business. So if all of those things are in place, then it's possible for you to protect it as an invention, and then you get a patent. Now that patent gives you protection for 20 years, and it means that no one else can use your invention unless they pay you a licensing fee. So it feels like, if you are able to find that little gap in the market that's never been used before, a really powerful tool in the IP portfolio. And it is, but because it is a monopoly, it creates this permission for you and only you to use your invention. It's a really strict procedure to get through. And that strict procedure might take you years and years. And it will cost you thousands and thousands of pounds. Most maybe 10, 15, 20, up to £30,000 just for protection in one country. And it's always worth having an international view on patent protection because of the international marketplace. The last thing you want is to have protection in the UK just to find someone else in the US picks up the technology, uses it over there, and you've lost the marketplace. So that's all I think we're going to say about patents today because of the costs and expenses of doing it. And the thing to remember is to make sure you have some advice before the invention is made public. Because as I said at the beginning, the moment it's not new, you can't register it. And the test is, does anyone know about it on the day that the paperwork is sent through to the Intellectual Property Office? So it's a really strict time limit on that. And once it's in, we can spend years and years and years debating on whether the patent should be given or not. But that key date is the application date, and the examiner will ask, was it new on that date? And there's cases where someone's told their neighbour about their wonderful new invention, and that's been enough to completely scupper their chances of getting the patent through because they've filed the paperwork the day after. So for the purposes of today, IP number 2 is patents, and the costs and expenses of that are horribly expensive, but you get that wonderful monopoly protection over anything that's new on the day of the application for registration. So that one's IP number 2. Again, in all my years of doing IP, the number of patent applications I've handled is tiny. Mainly because most of us don't need to operate in a field that's brand new. What we're doing is using existing technologies and ideas and creations and inventions to help us deliver our goods and services. But that's all there. And again, I'll detail the process for you in the PDF. So patent's done. And IP number 3, if everyone's okay for us to move on again, is to talk about confidentiality agreements. Now, it may be that what we need to do to protect our business is to make sure that we're not telling the world about all of our secrets. You know, we only tell our secrets to people who are paying us for the pleasure. And I think that's a really delicate balance, because especially at this moment in time, we're kind of tempted to think the best thing to do is put everything out there which will help us with our marketing, but it might not necessarily help us earn a living. And I get there's a real tension between that. And certainly we do the same. You know, there's lots and lots of help and assistance we give for free, because we think that's the best thing for society, for our clients, our customers, our potential clients and customers. And that's the kind of space we want to inhabit. We want to be kind. But on the other day, I need to pay my Sainsbury's bill. So we've got to get that kind of balance right. And you need to help make sure that no one else runs off with the thing that makes your business, your services special. And on that basis, you can make sure that the people you're dealing with, the people you're talking to, the people you're working with, sign up and promise that they'll keep your information confidential. And we might put that in an email, we might put that in a formal legal agreement, but I think it is worth having at least that discussion so that everyone is clear about the fact that you may put value on some information and you want to keep that tight to make sure you're not losing out the opportunity of earning a living later on. It might be called confidentiality, it might be called an NDA, a non-disclosure agreement. Americans tend to use that phrase. And you can find examples of them all over the web. And if you want to make sure that the example that you want to use will do the job, just let us know. I'm sure we'll be able to take a quick look at that for you. But the idea is, don't give away everything too soon, and make sure you can trust the people that you're working with, dealing with, clients, contacts, so that you are giving away the right things to the right people at the right time. And if you need to back that up, then back it up in writing, on an email, something, so that if something goes wrong, we've got the basis on which that arrangement was put into place without any arguments. And of course, that links closely to the idea of looking after personal data and the GDPR rules and regulations, because the thing that might make your business really special might be the information that you store and the information that you've had in, some of which might well be personal data. So IP number 4 is around data and the value of your database. And it might be that your list of contacts, for example, it's worth a heck of a lot of money to another body. And you've got to make sure that you're in a position to use that data in the way that you'd like in order to earn yourself a license fee. But if it's personal data and you haven't got permission to share it and make money out of it, then that obviously is a GDPR issue. So patents, confidentiality, data, kind of all linked up in a way, but they all have their own role in that intellectual property portfolio. So that's where I think patents might be a little bit far down the line in terms of costs and energy that are needed, but confidentiality and data are what we deal with on a daily basis, and I think are worth just taking a moment to take stock to see if either of those might help you protect your position. And it also obviously works the wrong other way around. You know, if you're using somebody else's information or somebody else's data, check that you've got permission to do it. Okay, so that's 4 of the 5. I want to do the next one, which is design rights. And design rights, again, a little bit like trademarks in that there are 2 systems that go hand in hand. There's a registration process which again needs funds for registration to go through. And there's a freebie unregistered process. What's it about? Well, it says it on the tin. It's a design right. And these help you protect again, a new feature or a new configuration or a new way that something looks. And if you are the first person to put that design out into the public world, then you can protect it. So, for example, we've had glasses for hundreds and hundreds and hundreds of years, but the particular design of this glass, when it was new, could be protected. Because this is a glass that has this particular ribbed formation, configuration, and that is a design feature that can be protected. So if you're looking at creating a new way of something being seen, and it might be a new font or a new way that a website is designed, any of those things can be protected by a design right. But it's that kind of idea that it's the design of the item, not the item itself. The item itself gets protected by patents. So you can see how they all start linking up and the portfolio starts working together to help you. Now, the great thing about design rights, you get a level of protection for free. And if you do want to go through the registration process, you've got some time to decide whether you want to register a particular design or not. The definition of new for designs is different to the definition of new for patents, which I know is a bit confusing. I don't know why it is, but it is. So let's just live with that and say you've got a little bit of time, up to 12 months, to decide whether you want to go through the formal registration process. So we look after some jewellery designers. They come up with a new jewellery design. They put it on the marketplace. They test it out for 6 months. And if it's a really good seller, then they spend the money on protecting the registration of the design, and it goes through to their kind of stock for future years. If on the other hand it hasn't sold so well, they just let it go and they don't bother with the registration. The costs, well, a simple UK design registration under 100 quid. So yeah, again, it gives you a really good level of protection, but only for particular types of new design. So that's the 5 done. And I'm sure that some of those aspects might play into what you get up to on a day-to-day basis, but not everything. Completely get that, which is why I've saved the 6th and the last one for the best, and that's copyrights. So item number 6 in the portfolio is this thing called copyright, and I can promise you that you will have elements of copyright involved in your day-to-day business. So what do we mean by copyright? Copyright is the right to stop people copying your work. It's as simple as that. And the things that are protected by copyright are set down in a list that's been developed over hundreds of years. So some of the things feel a little kind of clunky nowadays in the technological world, but I know that anything that you create that is a written work, so using words, will be protected by copyright. Anything you create that's an artistic work will be copyrighted, and anything that you produce that's a dramatic work or a musical work, automatically protected. And then there are some other things on the list, including things like sound recordings, films, broadcasts, cable programs, those kind of things, and how you put together some of that work like published editions. So this webinar, because it is being recorded, will be copyright protected. The kind of reports that I write, copyright protected. Any of the text on your website, copyright protected. Any of the graphics, logos and photographs on your website, copyright protected. No one is going to check to see if you have written the best prose in the world. There's no test for quality. It's the fact that it's been created and it exists in the physical world that enables you to protect it using the copyright rules and regulations. So I'm just going to pause there and double check. If anyone's not clear on whether what they create is protected by copyright, just let us know in the chat bar. Because if you're not on the list, you don't get protected. But the good news is that almost everything that I can think of that you're dealing with on a regular basis will have that automatic copyright protection. So while you're just having a quick think about that, and we'll just check, Grace, just to let me have a sip of water. Do you know what the copyright symbol is?
It's a C in a circle.
Yep. So again, like we said, R in a circle for registered trademarks. For copyright, it's C in a circle. And again, everyone around the world uses that international symbol. You don't have to use it, but it's a really good idea if you do, because more and more people get educated about what the rules are. And I'm a great believer, if you tell people to respect your work, the odds are they will. You know, if they recognise that there's value in it, then why wouldn't they? So that's the international symbol. You don't have to use it, but it really does help, especially if there's things, international exchange, then we can get the border patrols and people like that to help us protect our work as well, if it's seen to be used with a copyright symbol. So it's a freebie, another free one. There's no registration process for copyright in the UK. As soon as you've created it, it will be protected. Over in the States, it's a very different system, and you do have to register it if you want to go into court to protect it. So watch out for that, because if you search for copyright online, there are lots and lots of people offering to register your copyright for you. Don't do it, waste the money, keep your money for other things. So having said that, it's a freebie and it gets created automatically once you've created something in the big wide world. Let's just double check who owns the copyright in the things that are being created. And it's a really simple rule that says that the person who creates the work will own the work unless, and there's always an unless, isn't there, especially when a lawyer's involved, the owner is creator unless they're an employee, in which case the employer owns it, or it's been created and there's a deal done in order for the IP to be transferred. And that's it. So simple rule, you will own the copyright of everything that you create, and that's great, unless you're an employee, in which case your employer will own it automatically if it's been created during the course of your employment. And you can sell on the rights in an IP work if you want to, but you've got to do the deal. It's got to be a formal legal assignment, a transfer of the ownership for that to be valid. So if you want to ask somebody else to write some text for your website and it's not your employee and you do absolutely nothing else, then by default, the person who wrote the text for your website will own the copyright in that text. And although it's clear that you're going to use the text on your website, you end up then in some sneaky, difficult positions if you then want to use the text for something else. Because then that deal that you did when you commissioned the writer didn't mention anything else. And in that kind of circumstance, by default, you'd have to go back to the writer and ask for a new permission to use it for something else. And that might well come at a new fee. So doing the right deals, if you're buying in other people's work, is key. And also understanding that you can license out the work that you create because it's automatically protected by copyright could be a really useful tool for that. So ownership of copyright, it's going to be the creators unless you're an employee or you've done a deal. One of the things that people sometimes do to help them prove it's their work is to put a date stamp on it, which is a really good idea. Put the copyright symbol, really good idea. All rights reserved is a 3-word shorthand for just telling people it's protected. And some people stick it in an envelope, seal the envelope, and post it to themselves. And you might think that sounds like a bit of a strange thing to do, but it's a way of putting a date stamp on a copy of the material that's that's been done by a third party, the Royal Mail. So as long as you keep the envelope sealed, if there's ever any argument about who's copied whose and who created the work first, you've got a copy of the work in a sealed envelope with a Royal Mail date stamp on it. And that's been a way that's been used over the years to help prove when a work has been created that's relatively cheap. Obviously, if you've got it in your workbooks, if you've got it on emails, if you've got it, date stamped on your computer systems, anything like that, that's always really good help as well. But obviously, it's on your systems, and then sneaky lawyer can turn around and say, "Aha, but you've fiddled with the dates." Whereas if you're going through the Royal Mail, that's an independent body that's date stamping it, and that's seen to be better evidence.
Keith, could I just very quickly interject, because Lisa has just asked a question around that subject there. Right. She's asking, would that count if it's a photograph of the material?
Well, again, it helps us prove that the material existed on that date. So you might have created a work, let's say, on the 1st of June. You might take a photograph of it on the 25th of June, stick it in an envelope, send it out in the post. So then I know whatever was in that envelope existed on the 25th of June. And obviously you can't take a photograph of a work that doesn't exist. So that really does help. You don't have to put an original in the envelope, but it gets the date stamp of when it gets sent through the system. But the top tip there is to keep the envelope sealed. We work with a lovely poet in the Doncaster area who receives the envelope the day after. And I think he gets so excited that he's got some post that he opens the envelope to double check what's inside it. And of course that destroys the whole purpose, because you've got a sealed envelope, and that's how we prove that whatever's in the envelope existed on the date it was posted. So it's a really simple trick, and it doesn't cost that much, but it does give you that independent date stamp. If you don't fancy doing that, and you don't want lots and lots of files with unopened envelopes, you can always give them to a third party to store for you, and some solicitors can do that for you. And again, because I'm an officer of the court, my overriding duty is to tell the truth to the court, so I'm seen as a good witness saying I had a copy of that, I had a photograph of it in my files on the 25th of June. But then of course you've got to find a friendly solicitor. Anyway, so having sort of said there are ways of proving it's yours, and there's ways of proving when it was created, the next question is, okay, I've got copyright, but how long does it last? As I said, trademarks can last forever. As long as you renew them every 10 years, you'll be able to have protection for a brand forever. Patents last for 20, maybe 25, depending on which country we're looking at, but for fairly long. But once they've past their time, they go into the public domain and anyone can use them. And again, design rights only last for a certain amount of time, and then they end up in the public domain. So here's the pub quiz question. How long do you think that the rights for copyright might last from the day on which it was created? And it's a bit of a trick, because there are different time periods depending on the type of material that we're looking at. But the good news is that all those works of artistic craftsmanship, all those literary works, get protected automatically for a very long period. And that period is for the life of the person who created it, plus 70 years from the end of the year in which they die. So it's life plus another 70 years after the end of the year in which they die, which for most of us means that we've got plenty of protection, and we've got that opportunity for our estate, under our wills, our family, or whoever else we want to nominate to benefit from our estate after our death, to carry on earning licensing fees from the work that we created whilst we're alive.
Could I just chip in with another question? So Sally has just asked, can patents and design rights be renewed, or do they always default after 20 years?
They have to go through a renewal process during that 20 years, but they then get to the end of the journey and then they go automatically into the public domain. So yeah, but the point is, for all of those, it's fair to have a bit of protection because of the investment you've made in your inventions. But if it's locked in forever, then the marketplace isn't ever going to move on. So that kind of 20-year was thought of as being a fair kind of return of investment. But then once it's done that, the deal is everyone has access to it because everyone's got access to the intellectual property database. So sometimes there is a bit of a balancing act. Is it better to keep it secret, confidentiality, or is it better to put it on the public register, have a monopoly for 20 years and then let it go? And let's face it, there's not a lot of technology nowadays that lasts for 20 years. But some of the big pharmaceutical companies are spending hundreds of thousands of dollars every year to protect their IP in their patent protection portfolio because of the value that they can build in over those 20 years. But after 20 years, we can all go into the chemist and buy an aspirin, we can buy a paracetamol, because they've gone through that patent protection and fallen out of the period afterwards. Much the same with copyright. Once we've done the 70 years after life, then anyone has access to the material. So that's the reason why we can all put on a Shakespeare play. He's been dead for over 70 years. So it's good to keep the records and know who's created stuff in order for us to look back. And we've had to deal with cases where people have wanted to use old material, and we've had to do that checking to make sure we know who created it and when they died. It's slightly awkward because, say, some things like film and music recordings have a different lifespan to the actual lyrics and the notation of the music. So music and lyrics get life plus 70, but the recording of the music and the lyrics gets a shorter period. So they all build on each other and they all get a bit more complicated. But for today's purposes, I think we can say you get protection for long enough for it to be valuable. And once you've got protection, you can stop anyone else from copying it. You can stop anyone else from copying a substantial part of it. It doesn't have to be the whole of it. You can stop them selling copies to the public. You can stop them broadcasting it, showing it, performing it, and you can stop them adapting it. So it's a really powerful right that you get for free. And I think that's why it feels like it's a core part of what we do on a day-to-day basis. But once you've got it, what can you do with it? Well, you can give permission to other people to use it on your terms. And I think that's where it gets really interesting, because I can say to Curious Minds, I'm more than happy for you to use this recording on these particular terms. I can say you can only put it up on your website for the next 3 months if you pay me £1 million. And if we agree to that, that's the deal. If on the other hand, I say I'm more than happy for you to put it up on your website for free for the next 3 months, then that's the deal. And that's absolutely fine too. And that's one of the ways that you can start feeling your way through about what to make public for free and what to make public as a fee. So freebie stuff can be time limited. It can only be used for certain circumstances. The paid for content can be restricted, and that helps you make sure that there's a way of making money from it. And if you're not sure about the terms on which you need to go for, there is a standard that's been created. And in one sense, it's a really useful standard because, again, it's there already for you to use, and it's called Creative Commons. And a Creative Commons license has a little kind of pictogram that goes with it. And by just looking at the pictogram, you kind of know what the deal is if you want access to it. So one of the little symbols says PD for public domain. And if the work has a little PD symbol attached to it, you know you can use it without going into any more discussion or getting into any more of the detail. So it's worth having a quick look at Creative Commons to see if that's a really simple, quick and easy way of creating licenses to allow other people to have access to your work without needing all the hassles of going through creating the documentation for yourself. There's disadvantages as well, because it's international, that the wording's a bit American, and I think it gets a bit more complicated when you start getting behind the pictograms. But it's a good place to start. It's a good thing to test out your thinking about what should be given away and on what terms should it be given away. So should it be for free? Should it be time limited? Should it only be for a particular type of use? We've dealt with a photographer who was asked to create imagery for a local theatre show, and the deal was done that, small fee for that, but the show moved to the West End when the budgets were bigger, and because the first deal was done properly, the photographer could ask for a second license for that second use. And that's the great thing about intellectual property, that it means that the things that you have in your portfolio, you can use and use and use again, and each time you use it, you can charge another fee. Obviously, it works the other way around. If you need works from third parties in order for you to be able to deliver what you need to deliver, you need to do those deals on the right basis as well. You need to identify who owns the works, who owns the intellectual property rights in them, and you do the right deal. If you're not sure who owns it, it becomes a bit difficult, but there is a provision with the Intellectual Property Office where they can license it on behalf of a missing author. So that they're called orphan works, and there's a system for that as well. There's lots of other things that hang off the back of that. The right to be named as the creator, that's called a moral right, and the right to receive a license fee if your work is resold again through a professional gallery or auction house, things like that. That's called a resale right. But all of those things hang off the back of the fact that you have copyright in your intellectual property rights. So they're the 6. They all kind of link together. They all do slightly different things, which is why it feels a bit confusing at first glance. But I've listed them all on that little PDF of everything we've spoken about, and we'll make sure that comes out to you after the session. The great thing about IP is that when you've got it, you can use it. And if you can use it, you can make money out of it. And if you're making money out of it, then sometimes it's worth having this conversation about what should be protected. How far do you go to make sure that your portfolio works for you and doesn't cause you difficulties later on? And that's the bit of a balancing act where lawyers and accountants and other professionals can help get you a bit of sense of where's the best place to put your budget. And I'm conscious we're kind of 5 minutes away from the end. Is there any more questions we need to quickly pick up?
We've just had one, and Keith, we'll probably have to go very, very quickly through it because I can see we're just approaching 11 o'clock. So I don't know if we can go too much in depth on this question, but Sal's asked a question about enforcement. So is it straightforward to pursue an infringement claim, or does it get expensive?
Oh, whenever lawyers get involved, it's going to get expensive, isn't it? So some steps for enforcement are really easy. It might be that all you need to do is pick up a phone and say, "Oi, stop it," and that sorts it. Sometimes people are using your works online in people's Facebook accounts and Instagram posts, and sometimes just writing to the social media platform can help get it taken down. So there are some simple steps that are really cheap and cheerful, and they're absolutely fine. The more complicated things like taking out an injunction to stop someone using your work, that's going to cost you £20,000-30,000 and take years. So, there's a balancing act. There are some things that are simple and worth doing. There are some things that, you have to take a view on.
Lovely, thank you very much. I think we'll have to leave it there because we are fast approaching 11 o'clock, but just to say thank you so much for this morning's session. I think everybody was furiously jotting down notes there throughout that past hour or so. Just before we leave, as I say, thank you again to Keith and Grace for this morning's session. So following today's session, as I say, we'll put the recording of the webinar up on the Curious Minds website, and we'll also send you a quick evaluation from today's session. So if you could just take a couple of minutes to fill that out and give us a bit of feedback around this session so that we can continue to develop online sessions for you that you really need in the coming weeks and months there for you. We'll also make sure we include that PDF in that email that Keith was talking about there, so you have that resource to hand. But apart from that, thank you very much for joining us today. Go and enjoy the lovely warm sunshine out there now. And to leave the session, please just click on at the bottom of your Zoom screen. There's the little tab that says leave, so that'll take you out of the Zoom session. But thank you very much, everybody, and we hope to see you all again soon. Take care.